Ready, start. The Chief Justice, Shil Nagu, has rejected the preliminary objection raised to the jurisdiction of a single bench of the Punjab and Haryana High Court, Chandigarh, on May 23, 2025, by the senior counsel Mukul Rohtagi, appearing with advocates Puneet Bali and Rakesh Nehra, seeking quashing of FIR para. The Chief Justice took emergent step by withdrawing the instant case, which was heard and reserved for pronouncement of judgment, and listed the same before a newly constituted single judge bench comprising the Chief Justice for rehearing para. The CJ, with a view to preserve the dignity and honor of the institution and so also the public trust, took the emergent step para from a closer scrutiny of the ratio of various judgments relied upon, and having gone through the rules and orders of the High Court of Punjab and Haryana, the CJ found that there is no express or implied bar for the CJ to withdraw any case which is heard and reserved for judgment by any particular bench, and list the withdrawn case before any other single bench comprising any other judge or the CJ para. Powers of Chief Justice as Master of the Roster are wide pervading and plenary. These powers are circumscribed by only one consideration, that is to protect the interest of the institution from being tarnished and to uphold the public trust reposed in judiciary by litigants. If these considerations are kept in mind, then the power of the CJ of allocating a particular case to any particular bench or withdrawing a particular case from any particular bench and allocating the same to any other judge are untrammeled and immune from judicial scrutiny. Para. This petition has been filed under Section 528 of Bharatiya Nagarik Suraksha Sanhita 2023 for quashing of a FIR of April 17, 2025, alleging offences punishable under sections 7, 8, 11, and 13 of the Prevention of Corruption Act 1988, read with section 120B of the IPC, registered at Anti-Corruption Bureau, Panchkula, Haryana, against the three named and some unnamed accused, including the petitioner, with further prayer to stay the proceedings emanating from the said FIR para. The reason for withdrawing this case from the single bench roster of Justice Mahabir Singh Sindhu was the receipt of complaint, oral as well as the written, which impelled the CJ to requisition the record of this case from the said single bench of constitute another single bench comprising the CJ himself on May 12, 2025, to give quietus to the complaint, draw curtains to the controversy, and save the institution and the concerned judge from any further embarrassment by deciding the case expeditiously as possible. Para. In that attending factual scenario, if the CJ has not taken preventing emergent steps, then the CJ would be failing in his duty and belying the oath taken by him. The only course available to the CJ in the limited reaction time was to withdraw the heard and reserved case from the single bench of Justice Sindhu to be listed before another single bench. The object sought to be achieved was to prevent possible damage to the reputation of the institution para. The administrative power available to the CJ of making amending the roster includes within its ambit the power to assign and withdraw cases from any bench if an exception to this power is accepted by excluding those cases which are heard and reserved, then the object behind this power will stand defeated para. The object is to ensure administration of justice by allocating cases of different nature to available benches to achieve the ultimate goal of fair and speedy justice to the litigants. For achieving this objective, the CJ performs the ancillary function of looking into written or oral complaints against any particular bench. This function is discharged by subjective assessment based upon objective material in hand, which may be in shape of written or oral complaint. Occasionally, such complaints are received at the 11th hour, as in the present case, when the reaction time with the Chief Justice is limited. Thus, the CJ has to decide within this limited available time as to which course of action is to be taken para. In such situations, the reputation of the bench which heard and reserved the case to be withdrawn is at stake. On the other hand, is overall reputation of the institution and public trust of people at large in the judicial system. In this piquant situation, if the CJ chooses the latter, then in the judge's humble and considered opinion, the CJ stands by his oath and public trust para. It has been contended by the senior counsel for the petitioner relying upon the Supreme Court decision in the case Shanti Bhushan versus Supreme Court of India through its registrar and another 2018 8 SCC 396 that power of the CJ does not extend to regulate judicial functioning of a particular bench since the bench by mere fact of assignment of roster or administrative order acquires complete dominion over the assigned case para. It is no disputed that the Chief Justice is the master of the roster, but once assignment of case is made by the CJ to a particular bench by way of roster or by administrative order, then that case falls within the exclusive domain of the assigned bench till its decision, except where the roster is changed or the CJ allots that particular case to some other bench. At this juncture, the counsel for the petitioner pointed out that when a case is heard and reserved for pronouncement of final order, the Chief Justice CJ stands denuded of any such power of assigning the case to any other bench para. In this decision, as regards the powers of Chief Justice, it was also observed that though on the administrative side, control of the High Court rests in the CJ alone. On the judicial side, however, he is only the first amongst the equals para. The High Court has voiced its considered view that the objection raised by the senior counsel on behalf of the petitioner deserved to be and is rejected.